Now in Maryland, the police can arrest you and conduct a full custodial search of your person if they testify that they have detected the odor of marijuana coming from your breath or from your person. In a 2-to-1 decision, the Maryland Court of Special Appeals in Lewis v. State upheld such a search. In that case, a police officer testified that he detected the odor of marijuana coming from both Lewis's breath and his person. He arrested him, and incident to that arrest recovered a weapon. The court made it clear that its holding was not affected by the fact that Maryland has decriminalized the possession of less than 10 grams of marijuana, and the fact that Maryland has now begun a medical marijuana program does not affect the court's decision as well. The Maryland courts and other courts have always upheld the odor of marijuana as providing probable cause for the search of a vehicle. The Maryland courts have previously distinguished, however, the fact that an odor of marijuana coming from a vehicle does not justify the frisk and pat-down of all the occupants of that vehicle without something more to persuade the courts that the police officer had reasonable suspicion that the person was armed and presently dangerous. Maryland's courts continue to struggle with the change in the law, in the environment, and public attitude towards marijuana. This decision now gives police officers who are looking for a pretextual reason to search an individual for reasons other than a belief that they may have possessed or smoked marijuana the opportunity to arrest them, and then under the law, once you are arrested, the police can conduct what's called a custodial search of your person, meaning they can not only pat you down, they can go into your pockets and they can conduct a full body search. In the Lewis case, one of the judges made it clear that he was troubled by the decision that they had to reach in that case. He noted, and I will quote from part of his opinion, that it is undeniable that the decision in this case will result in injustice. Under the decision, an individual can be subject to the indignity of an arrest and a search incident to an arrest, and if the search turns up nothing, there is no civil remedy. The mere odor of marijuana on a person or his breath gives them the right to arrest and search. This judge also pointed out the difficulty of ensuring that police act appropriately by noting that this decision could permit an individual to be searched even though their clothing reeked from secondhand smoke. The individual may have been in a jurisdiction like the District of Columbia and have smoked marijuana in that jurisdiction, smelled of the odor of marijuana, but had no marijuana on their person when they were in Maryland. A number of other scenarios are obvious. A person with a medical marijuana card may have legitimately and legally smoked marijuana, yet they are subject to the indignity of an arrest and a full body search, even if that search ultimately is going to turn up nothing. One of the judges in that case, the one who actually dissented, said the real-life consequences of holding that police have probable cause to arrest a person and conduct a full warrantless search incident to that arrest based solely upon that odor of marijuana caused great concern. This is a case decided by the Intermediate Maryland Court of Special Appeals. It would not be unusual for the Court of Appeals to review this decision and to either affirm it or reverse it based upon the conflicting kinds of public policy discussions that are going on in the courts as to what the police can do when they are basing police actions simply upon conduct that has either been decriminalized or legalized, but still may provide probable cause to believe that a person is possessing a quantity of marijuana. One of the issues also raised in the case was, how do the police know when a person has the odor of marijuana, whether what they are possessing is less or more than 10 grams? It is still a criminal offense in Maryland to possess more than 10 grams of marijuana. While possessing less than 10 grams of marijuana is now a civil offense, the court has previously concluded that it is still contraband and it is still subject to being seized. This is an ongoing discussion that lawyers, judges, and appellate judges will be having as they try to come to grips with a changing mood in the political and legal climate regarding the use and possession of marijuana.